you need to be 100% certain that you're permitted to go wherever it is you're driving, because if you're not and you get pulled over, you're going to get cited for driving under an OVI suspension. That offense has a mandatory minimum of 3 days in jail, and unlike the OVI, there's no alternative. It's 3 actual days in the jail. So if you get driving privileges and you're not 100% sure you're allowed to be going where it is you want to go, don't go until you verified that. Understand? Now, do you have any questions today? Anything further, Mr. Breen?
I have 2 questions. So she has the interlock on right now. Is that?
It's usually, it's very common for me to require an interlock on a pretrial basis because I don't know anything about the defendants and I don't have any close supervision of them.
Right.
It's also very customary for me after a conviction for a first-time offender to remove that requirement.
Is that off now? Interlock?
Well, she'll have to continue to use it until she's granted a new modifying order that does not require that.
So I can have her fill that form out at the clerk's office.
The application
Yes,
for
sir.
privileges, yeah, the bailiff can assist
Okay,
with that.
very good. And then second question is, how would that work if she ends up in Chicago with her reporting requirements for probation? Is that?
She'd have to talk to the PO, but my understanding is that they do Zoom appointments and things of that nature. All they're really going to want to see from her is no new arrests and a certificate of completion of the DIP.
I just didn't want to get in a situation where she's going to have to drive back once a month or something. I didn't think that would be necessary, but I just wanted to double check. So
My understanding is that for first-time OVI offenders, they're not required to report on a regular recurring basis.
And I think
Just
we
when
probably
required.
both had cases where people are like, oh, I'm just going to move, tell them I moved out of county, and they never report. But she's not like that. She's a very nice person, and
I've always said if voluntary banishment was a sentencing option for this court, we'd have about half our population.
Right.
Ms. Yeager?
Nothing for. This is exactly what happened. Nothing more, nothing less. I don't have any memory of swerving to the right or into the right lane, and that doesn't mean I don't recall. That means I did not. The lane change alarm did not go off. The steering wheel did not resist. What happened was instant. I reached past the snack while looking, and then heard and felt the impact. Sorry, not looking at my child, looking ahead. There was no swerving, no lights flashing, no alarms going off, no wrestling with the steering wheel. Immediately after I pulled over, I called 911 and reported the accident. After a minute, the trucker came out of his cab and said, I saw you kept swerving and tried to swerve away to avoid you, but you kept
Your Honor,
coming.
this is hearsay.
Well, let's see if it's a statement against interest. You may continue.
Okay. There's no damage to my truck, just a little scratch. You don't need to call the police. Don't call the police. You can do the repairs yourself. That was the first lie before the collision. I was not swerving at any point, and certainly not repeatedly, as he claimed. I had steering assist on, which actively prevents swerving, and I was also still in control of the vehicle, looking at the road, and would have known myself if I was swerving.
For the record, the objection will be sustained.
Thank you.
You may continue.
Okay. I took his word for it because I was very confused and didn't know how we ended up in a collision when I was in my lane and he was supposed to be in his. I simply assumed that since he was so confident about what he said, I must have been wrong. I told him I had already called the police and that I thought it was legally required after any collision, even one where there's no injury. He said I could call back and tell them not to come and that he was just trying to help me out. But I replied they were already on their way. I thought it was odd for him to suggest something illegal, but assumed he was just trying to do me a favor or be nice or something. At this point, I was profoundly disturbed and shaken up. I'm a young mother. I'm traveling alone on a long trip with my infant and my toddler. My infant on the truck's side, my toddler is on my side. In the incident of collision, my biggest fear was that my infant had been killed or seriously injured. After this, my simultaneous relief that he was alive and unharmed and my confusion about how the truck hit us left me very vulnerable to suggestion. By telling me that he saw me swerving and tried to move, I assumed he must have known better and more of the story than I did, because all I remembered was passing the snack and instantly feeling the impact. My mistake was to assume that he knew better and then also would say better, would tell the truth. I had the facts that I knew, couldn't make sense of the blank in the middle, and then filled in that blank with what he told me. And then repeated his version of the story in the middle with the parts that I was not understanding. Next, when the officer arrived, I added in the assumption I must have swerved over. I don't know. I don't know what happened. I repeated that many, many times. I don't know what happened. This kind of confusion is extremely common after a collision and shouldn't come as a surprise. The responding
Objection.
officer...
That's an expert opinion.
Sustained. You may continue, Ms. McRae.
The responding officer did not ask me if my driving assist was engaged, although he did mark on the crash report that it was not engaged. I don't believe it's I'm not the one asking the questions about what happened. I'm the one responding to the questions. I can only respond to questions that have been asked. It is not my duty to know what's on a crash report and fill out the crash report. I'm not the responding officer. So that question should have been asked. When the responding officer came back to me to take my statement, he asked me if I had been on my phone. Horrified, I said no, because I had not been. I'm driving my children. He said, I'm just asking because I have to, and the trucker said he saw you on your phone when you hit him. This should be sustained by the officer's body cam at the time, at the scene of the collision. I was absolutely bewildered because if he had in fact been able to see me, he would have seen that I was not on my phone. He would have seen everything that happened, although that now makes me wonder why he was watching me instead of watching the road himself, and he told me earlier that he had already been swerving. This is the second lie. At no point during the drive was I on my phone. My not-in-service GPS and music device was plugged into the car. Its apps were inaccessible because I had no internet access, and the GPS was operating through the car. My dumb phone, so-called, was put away. At the scene, I even offered for the responding officer to do a forensic analysis of my devices to prove that I hadn't touched them, that I was not on my phone. He said that wasn't necessary as no one was hurt in the accident, no one was killed. It wasn't big enough fish to fry to bring out forensic analysis. Examining the damage to the car, I realized that the impact did not clearly decrease in severity from front to back, as would be necessary if I had swerved into him. Instead, the damage was slightly greater from front to back.
It calls for an expert opinion for
I
crash.
think a layperson is able to determine what the results of the collision would be, that's someone who's been a driver for a while, so I'll overrule the objection. You may continue, Ms. McRae.
Thank you, Your Honor. Instead, the damage was slightly greater from front to back, which is consistent with a tractor-trailer fishtailing perhaps into a smaller car, rear end first. The damage is also not a swipe, which it would have to be if I had scraped along him. Instead, it's a lateral impact nearly evenly distributed along the car's body with a clear puncture at the front of the vehicle. I have a zoomed-in photo of the damage to the car, if I can introduce that.
Ms. Kyle, will you go ahead and get the exhibit from the defendant and publish that to the prosecutor, please? What have you marked that as identification purposes, for identification purposes as? Defendant's exhibit what?
Exhibit A, is it an exhibit?
We use
Okay.
letters for defendants.
Okay, thank you, ma'am.
We'll just go B.
Okay. So instead it's sorry, Your Honor, should I wait?
Okay, you may continue, Ms. McRae.
Thank you, Your Honor. Instead, it's a lateral impact nearly evenly distributed along the car's body, with damage to the headlight, because that's rear view mirror, because that's a more vulnerable point of contact on the car, with a clear puncture at the front of the vehicle. Tears happen with side swipes, punctures do not. I have spoken with a 28-year veteran of the Cincinnati Police Department, and after hearing that I had been in an accident with a commercial vehicle, that the trucker claimed I hit him while I had steering assist engaged, and that the trucker then asked me to not call the police. This officer said he believed the trucker hit me, given the evidence.
It'll be sustained. That's hearsay. You can't testify as to what somebody else said out of court.
I understand, Your Honor.
You may continue with your testimony.
Okay. I'm asking for a dismissal of the ticket based on the lack of evidence beyond reasonable doubt that I was at fault.
Anything else you want to add to your testimony?
I don't believe so.
Ms. Shager, cross-examination?
Yes. Ms. McRae, what do you do for a living?
I'm a stay-at-home mom.
Okay. Have you had any training in motor vehicle crash analysis or anything like that?
I've been driving for about half of my life, and I've
So
seen a
no?
bunch of things.
Or
Not
any
formally.
formal training is what I meant. And do you do your own maintenance on your Subaru?
Occasionally.
Okay. When was the last time you had any of your equipment calibrated? In your
My husband took it in for an oil change shortly before the collision, and they do a standard tune-up.
standard oil change stuff? Where they look at everything.
They rotate and switch tires. They check the alignment. They make
And
sure
that
it's in
day,
good working order.
You said you had your dumb phone and all that, but was the music on and playing for your kids?
Not for my kids. I mean, it's playing in the background.
Okay, but so there was audio on for that and for your GPS?
My GPS does not work with, it doesn't operate with
It doesn't
audio.
have Bluetooth?
Yeah. Well, I guess it could, but I don't prefer to drive it like that. I find it alarming. It's like another person in the car all of a sudden.
And you recall the statement that you wrote for Trooper Sawyers here?
I do.
Okay. And as he read it here today, is that the statement that you gave him on that day?
It is the statement that I gave him.
Nothing further, Your Honor.
Now, is there anything that you'd like to add to your testimony based on the questions that you were asked by the prosecutor?
I would like to add that it is, if I'm referring to myself, is it expert testimony? If I say, I am like this in such a situation, am I speaking as a psychological expert, and do I need to be a psychological expert, or can I be speaking for myself?
You need to stop overthinking and just testify as to what you want to
All right, sir.
testify to.
I was extremely disturbed at the time, and I wanted to have a narrative that made sense to me to explain what happened, because what happened was almost horrific. And what I said to the officer is what I believed, explained what I knew. On calm reflection, I realized that I was making assumptions and speaking assumptions as if they were the truth. What I can swear to in a court of law as the truth is very, very simple, and it does not involve me swerving out of my lane.
All right, and any cross-examination?
No, Your Honor.
All right, so, Ms. McRae, you can go ahead and collect your things that you brought up with you. You can retake your place at your table. Did you wish to ask the court to admit Exhibit A into evidence?
I would, may I also give as Exhibit B the crash report with the inaccuracy about autonomous mode?
Any objection?
There's no authentication or anything. I think it's part of the record.
We'll go ahead and we'll admit it. Go ahead.
Okay.
Ms. Exhibit
The
B,
car
if you
has a
would.
black box that can be checked to confirm that.
Do you have any objection as to Defendant's Exhibit A coming in?
No, Your Honor.
And the state's objection to Exhibit B is noted and overruled.
Thank you, ma'am.
All right, Ms. McRae, you can retake your place at your table.
Thank you, Your Honor.
And you've already indicated you did not have any additional witnesses to call, so do you rest your case?
I do, Your Honor.
All right. Did the state wish to present any testimony or evidence in rebuttal?
No, Your Honor.
Did the state wish to make any argument?
Yes, Your Honor. Ms. McRae was cited for an basically an improper lane change, where she swerved into the lane that was then occupied by a semi with an attached trailer. And to do so, you have to exercise, if you're going to actually change lanes, you have to exercise due care to ascertain that you could do that with reasonable safety. It sounds like from Trooper Sawyers and from her statement that she wasn't intending necessarily to change lanes, but that for whatever reason she did swerve into the right lane and hit the semi. She told Trooper Sawyers that day that she did swerve into the other vehicle, and here today, even when she testified, she said that on the day in question, when she was a bit emotional, but what she knew was she was driving, she went to hand her child a snack, and then there was a collision, and there was blanks in the middle about what happened, and that she specifically herself says, I don't know what happened, and that since then she's just been trying to fill in the blanks. We believe that we've proved beyond a reasonable doubt that Ms. McRae did commit the violation of Revised Code 451139, and we would ask for a finding of guilt today.
All righty. Now, Ms. McRae, you have a right to make a closing argument. It's not required, nor is it evidence, and you can't bring up anything that wasn't either testified to by you or the trooper or any of the exhibits that have been admitted into evidence. You have to confine your argument to the evidence that's been admitted into the record. So with that understanding, is there anything that you'd like to say before I make my final decision about whether the state has met its burden?
There is, Your Honor.
Go right ahead.
I believe the officer did his job thoroughly and competently. I believe it has not been proven beyond a reasonable doubt that I made an improper lane change. There is no eyewitness testimony. There is a statement of a confused and distraught mother after the fact, and video body cam footage of the trucker lying about what I was doing at the time of the accident, and that can be substantiated by the video cam, the body cam
Objection not
footage,
evidence.
You may continue.
and a forensic analysis of my devices. And it has not been demonstrated from my car either that I swerved because I had steering assist on, and that makes it very, very difficult to make an unexpected lane change.
All right, thank you, Ms. McCrae. The state has the burden of proof, as I noted earlier, and for that reason, they have the privilege of making a rebuttal argument if they wish. Ms. Yeager, did the state wish to avail itself of that privilege?
Yes, Your Honor. We did want to address that. While we don't believe that this was necessarily an intentional act on the part of Ms. McCrae, we still believe we did prove beyond a reasonable doubt what occurred. That is, I know she mentioned about like no proof, because, you know, that happens with most crashes, is they are often not on video, and the officer investigating has to do just that and investigate, get information from both parties, and then if there is a third witness or a third party witness, that as well. That was not available. He spoke with Ms. McCrae. She admitted that she swerved into the other lane on that day. I also have a Subaru Forester, as a matter of fact, and while I am
Who's
familiar
arguing
with-
facts, not in evidence now, Mrs. Yeager?
I'm aware. So I am familiar with how that vehicle specifically works, including its lane change and lane assist. Thank you.
Thank you. Court finds that the state has not met its burden by all possible doubt, beyond all possible doubt, but the court does find that it's met its burden as to proof beyond a reasonable doubt. So I'm going to enter a guilty finding. In a minute, I'll explain to you, Ms. McCrae, how you can appeal my decision in whatever sense I'm about to impose. You do have a right to make a statement before I decide what the fine should be. We're not going to re-argue guilt versus innocence because I know you disagree with my ruling there. But other than that, is there anything you want to say about the fine?
You're the one put in authority. This is your competence to decide. I'm detached as to the outcome.
Okay, very well. Ms. Yeager, did the state wish to be heard regarding the sentencing?
Your Honor, we would just note that she does not have any prior moving violations, so we believe a nominal fine would be warranted.
Well, first and foremost, let me say I'm glad that neither of your children nor you were injured in the accident. I think there probably were some self-serving statements made by the trucker, especially given the fact that he didn't really want to involve the police. And ultimately, I did find that there was proof beyond a reasonable doubt. It wasn't proof beyond all possible doubt, but they did meet their burden. I'll go ahead and impose a $25 fine as well as the court costs. And Ms. McCrae, as I mentioned, you have a right to appeal my verdict and the sentence that I've just imposed. You have a right to have a notice or to file a notice of appeal within the next 30 days. That's your deadline to file an appeal. You have a right to pay for a transcript of our proceedings today, and you also have the right to hire counsel to represent you throughout the course of your appeal. And obviously, you can represent yourself if you wish on the appellate level. It's a much more complicated process and much more stringent as far as the requirements, what the Court of Appeals would require. Best example I can always give is, there's a certain page limit that your briefs on appeal can be. If the page limits say 15, and you're in the middle of a sentence and there's only one word that is on page 16, that one word will not be considered part of the record. That's how strict they are about that stuff. So if you decide you want to take it up, I would strongly encourage you to, at the very least, consult with, if not retain counsel to take it up. We're going to give you time to pay, and you'll find out the exact cost as far as fines and costs combined when you get down to the clerk's office. My bailiff will take you there next. Do you have any questions today?
No, Your Honor.
Anything further, Ms. Yeager?
No, Your Honor.
All right, very well. You may go with the bailiff. Good luck to you, Ms. McCrae.
Thank you.
And have a safe trip back down south. All right, next up we have the Seth Robles. Is it Robles? Robles? All right. So once the table's free, you can have a seat there at the table. Where in Virginia does your sister live?
She lives in Fairfax.
Okay. You have a good day, and I think the bailiff's waiting for you out in the hallway.
Thank
Take
you.
care. All right, Mr. Robles, go ahead and have a seat. This is case number 26 TRD 04898, and the defendant, Mr. Robles, is present in the courtroom today. He does not have an attorney with him. Ms. Yeager is here on behalf of the state of Ohio. He's been charged with a single count citation alleging failure to maintain reasonable control of a vehicle, which is a minor misdemeanor punishable by up to a $150 fine. Ms. Yeager, is the state ready to go?
We are, Your Honor. However, I believe the defendant wanted a continuance in order to speak with counsel.
And is that true, Mr. Robles? You'd like to talk to an attorney?
Yes.
Okay. Can you confirm your address for me, please?
I'm new here. Can I check my phone too?
Did you just move recently?
Yeah.
Okay. How's your English?
Um.
We can provide an interpreter for you for free.
Okay.
Would you prefer that?
I mean, I still want to talk to.
I mean, at your next court date, we can have what we typically do if it's
Okay, yeah.
just a hearing, we can call an interpreter on the phone. If it's going to be an actual trial, like a contested hearing, we bring an interpreter in personally, like an actual person.
Okay.
So I'll provide that we bring in a Spanish interpreter for you for the next hearing, okay?
Thank you.
All right. So are you still at the James Fenimore Drive
Yes.
address? Okay. I wonder if the developer was aware that Fenimore was the author's middle name and not his last name. But he got robbed of his Cooper. Okay, Mr. Robles, I'll go ahead and grant your motion to continue today. This will be the only time I continue it for the purpose of you being able to consult with an attorney. So if you do want to do that before your next court hearing. And it'll get set probably within about the next three weeks or so. And we'll send you notice through the mail again, all right? But I'm going to continue your bond, so you're going to sign off on some paperwork, and then you're going to be free to go, okay? You have any other questions?
Okay.
Anything further, Ms. Yeager?
No, Your Honor.
Do we need to take a recess? All right, we'll take a brief recess before we get started on our pleas. Statement on the record. And we are on the record in 25 TRC 10187. It's captioned the State of Ohio versus Emily. Is it Songer or Songer?
Songer.
Songer. She's here in the courtroom with Mr. Hall, her counsel. We have Ms. Yeager here on behalf of the State of Ohio, substituting for young Mr. Savage. And we're here for the purpose of a change of plea. The defendant is charged with speeding, operating a vehicle while impaired, operating after underage consumption, marked lanes violation. Now, it looks as though the state's going to be dismissing the OVI per impaired and amending, are you just fixing the, oh, this is an underage consumption, so we're changing it from operating after underage consumption to just underage consumption?
Yes, Your Honor.
Okay. And my understanding is that if the court were to grant those motions, Mr. Hall, it is your client's intention to change her plea from not guilty to guilty, is that correct?
That's correct, Your Honor.
And yeah, here we go. All right, and is that true, Ms. Songer?
Yes, Your Honor.
Are you aware that regardless of what the charge is, you don't have to change your plea and nobody can force you to do so?
Yes, Your Honor.
Did you realize that you're presumed to be not guilty until and unless the state of Ohio could prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did you know that you have a right to have a trial with either a judge or a jury of your peers?
Yes, Your Honor.
And did you know that at the trial you would have the right to both cross-examine your accusers as well as to compel the attendance of your own witnesses through the court's subpoena power?
Yes, Your Honor.
You would not be required to testify at trial, and if you didn't, it could not be held against you. Are you aware of that?
Yes, Your Honor.
By pleading guilty to the amended charge of underage consumption, however, you are admitting to committing that offense. And what that means is the state no longer has to prove anything in order for me to find you guilty. You understand that?
Yes, Your Honor.
Furthermore, by pleading guilty, you are going to be waiving your right to have a trial and the other rights that we've discussed. Are you aware of that?
Yes, Your Honor.
So if I accept your pleas and enter convictions here, I will impose sentence upon you. The amended charge of underage consumption is now a misdemeanor of the third degree. For the longest time, it was a misdemeanor of the first degree. Still a more serious charge than actually operating another vehicle after underage consumption, but that's a legislative policy decision. So you're looking at on that charge of up to 60 days in the county jail, up to a $500 fine. Any questions there?
No, Your Honor.
On both the marked lanes and the speeding violations, you face a maximum fine of $150. Do you understand that?
Yes, Your Honor.
Now, Ms. Songer, have you been threatened in any way or promised anything to get you to do what you're doing here today?
No, Your Honor.
Are you currently under the influence of any alcohol, drugs, or medication?
No, Your Honor.
Do you take any, are you satisfied with the advice and representation that you received from your counsel?
Yes, Your Honor.
And are you a citizen of the United States of America?
Yes, Your Honor.
Then the court finds that the plea and waivers have been knowing, intelligent, and voluntary. The court will grant the state's motion to amend and enter convictions accordingly. Mr. Hall?
Thank you, Your Honor. The court may remember this case. We had a suppression hearing on it a few months ago. The statements were suppressed. Client looks great on the video. I think we had real arguments, likely not guilty on the impairments, but felt that this would be a great resolution. But you'll see my client's completed the 3-day driver intervention program as a part of this. She just completed it last week. No follow-up was deemed necessary for this case. Your Honor, my client's been under the administrative suspension since the arrest back in November. The court granted privileges with the interlock. My client chose not to spend the money on the interlock, so she's been without privileges this entire time. I've known her mom forever, went to school together, graduated from Watkins back in '96, good family. Emily's also attended and graduated from Watkins. She's currently working as a property manager, works at a bunch of different locations. I'd ask the court to consider granting privileges under the ALS without the interlock. And that's all. Thank you.
All right, thank you. Ms. Songer, you have a right to address the court if you wish. Is there anything that you'd like to say before I make any decisions about your sentence?
No, Your Honor.
And Ms. Yeager, anything further from the state?
Your Honor, I did want to confirm that Prosecutor Savage did receive the verification that the defendant did do the DIP program, and we have no objection if you would entertain privileges without an interlock.
All right, thank you. $43,169. All right, very well. It's going to be the sense of the court as follows. On the underage consumption charge, it will be a $200 fine. On the speed, our traffic schedule calls for a $24 fine. Oh, actually, I'm sorry. That's a $44 fine because she did have a prior moving within the 12 months before being cited in this case. It's $25 on the marked lane. She'll get time to pay. As far as the privileges are concerned, you can submit a written motion with proposed judgment entry, and the court would take that under advisement. I'm not saying I'll grant it, I'm saying I won't, but just go ahead and submit that so it'll come to the court's attention. Ms. Songer, do you have any questions?
No, Your Honor.
Anything further on behalf of the defendant, Mr. Hall?
No,
On
thank you.
behalf of the state, Ms. Yeager?
No, Your Honor.
All right, very well. You may go with the bailiff. Thank you. All right, next up is going to be Mr. Colson. Okay, we're on the record in case number 25 TRC 10392, State v. Curtis Colson. That's you, right?
Yes, sir.
And he's here in the courtroom today with his counsel, Mr. Szymanski. We have Ms. Yeager here on behalf of the state of Ohio, on behalf of the state substituting for Mr. King. We're here for the purpose of a change of plea. The defendant's citation lists speeding, operating a vehicle while impaired, a marked lanes violation, and reckless operation charges. I have a change of plea form that only lists the OVI. Ms. Yeager, was it the state's intention to dismiss all charges other than the OVI, or was it expecting the defendant be entering pleas on those charges?
Your Honor, my understanding is that the defendant would be entering pleas to the other charges.
Mr. Szymanski?
That was not my understanding, Your Honor. I'm sorry. He has a related felony, and I'm going from memory, but I thought we were just pleading to the, I don't know, there's really much, like the reckless, it's all.
I'm just going off what Mike said.
Oh.
Yeah, we did a pretrial back in February. I don't have any notes that reflect that. If you want, we can move on to the other case and you can talk with your client about it.
I don't think it makes much of a, from a sentencing standpoint, it's not going to make a difference. That's
Okay, so he'll go ahead and
It
do.
makes Mike King
Please.
happy, Your Honor. It makes me happy.
Very well. So, Mr. Colson, after that exchange with your attorney, it's my understanding that you are going to be entering pleas of guilty to the charges of speeding, operating a vehicle while impaired, driving outside of the marked lanes, and reckless operation of a vehicle. Is that correct?
Yes, sir.
And are you aware that you're not required to plead to anything?
Yes.
You're presumed to be not guilty. The state has the burden of proof beyond a reasonable doubt, and you have a right to a trial that could be with a judge or a jury where that attempt would be made. Do you understand?
Yes, sir.
Did you know that at your trial you'd have the right to confront your accusers? Meaning after they testified against you, like the trooper or the officer or the deputy or whoever it was, or witnesses, once they finish testifying for the prosecution, you would have the right to question them at that time. Do you understand?
Yes, sir.
You also understand you'd have the right to compel the attendance of your own witnesses at the trial.
Okay.
You would not be required to testify during the trial if you didn't want to. Couldn't be held against you in any way if you didn't. Any questions about that?
No.
Now, by pleading guilty to these offenses, you admit to committing those offenses, which means you're relieving the state of its burden because you're giving up your presumption of innocence. You're also going to be waiving your right to a trial and the other rights that we've discussed. Do you realize that?
Yes.
And if I accept your plea and enter a conviction, I am going to impose sentence upon you today. The speeding, marked lanes, and reckless operation charges are all minor misdemeanors. Each carry up to a $150 fine. Understand?
Yes, sir.
The OVI charge, because it is alleged to be a first offense within a 10-year period, carries maximum penalties of up to 180 days in jail, up to a 3-year license suspension, and a fine of up to $1,075. Any questions about that?
No. No.
There are mandatory minimum penalties, which include a fine not less than $565, a license suspension to last for at least 1 year, and 3 days in the jail. Or in the alternative, instead of ordering that you serve jail time, I can order that you successfully complete a 3-day driver intervention program. Understand?
Yes, sir.
Now, Mr. Colson, have you been threatened in any way or promised anything to get you to do what you're doing here today?
No.
Are you currently under the influence of any alcohol or illegal drugs?
No.
Do you take any medications that affect your ability to understand what's going on around you?
No.
Are you satisfied with the advice and representation you've received from your attorney, Mr. Szymanski?
Yes, sir, I am.
And are you a citizen of the United States of America?
Yes, I am.
Then the court finds that the pleas and waivers have been knowingly, intelligently, and voluntarily made. The court will accept the same and enter convictions accordingly. Mr. Szymanski, would you care to make a statement of mitigation on behalf of Mr. Colson?
Your Honor, this was a terrible night. My client's gainfully employed. He's a good family man. He's a good guy. The bottom line is he was drunk. He behaved uncharacteristically and illegally. Regrettably, it resulted in law enforcement officials suffering an injury to one of her fingers. He's going to face that music in front of Judge Marcelane. He just completed his PSR, I think, just a few days ago on that matter. So this has been a terrible circumstance that the blame lies squarely with Curtis, which he recognizes, which we believe is an important step towards his ongoing rehabilitative efforts. Thank you, sir.
All right, thank you. Mr. Colson, you have a right to address the court if you wish. Is there anything that you'd like to say?
Other than what he's mentioned, I found new sobriety, new lease on life. Nice to drive by a bar and know you don't have to stop.
All righty, thank you, sir. Ms. Yeager, did the state wish to be heard any further regarding the matter of sentencing?
No, Your Honor.
All right. So when I see these cases and I see somebody's got priors and the priors are, I mean, one of your priors, I was still in high school, it leads me to believe and surmise that you had been on the wagon for quite some time, correct?
Yeah, I quit a couple years and
Okay. So I guess my biggest question in circumstances like this are, I mean, look, I presided over drug court for almost 14 years. I understand that relapse is a part of every recovery, unfortunately, or almost all recoveries. But what always gets me is getting behind the wheel. I mean, you can relapse without getting behind the wheel and driving. So what caused you to, number one, even think about getting behind the wheel? And number two, I mean, I can't think of a better way to get pulled over than going 100 miles per hour on the highway. So, I mean, what's going through your head that night?
apparently the alcohol just does that to people.
Here's the whole way of the timeout. Wait a minute. The judge knows that alcohol impairs you. The question is, why get behind the wheel of a car? Where does that decision-making process get screwed up? If you want to sit at home and drink yourself to death, that's one thing. But
Right.
why put yourself in this jackpot is what Judge Stansbury is asking.
Irrational thinking. I just don't know why I did it.
All right, now you were arrested that night, correct?
Yes, sir.
Okay, and I conducted your arraignment back on the 15th. Were you still incarcerated when I did your arraignment? I can't recall.
I don't think so.
How many
Did you see me on the TV?
3.
He was in for
Yeah.
3 days.
Okay, well, so here's the question. He got pulled over on the 12th of December, almost at midnight itself, basically. So the 12th of December was a Friday, and then he would have been released on his own recovery. So the question becomes, instead of doing the DIP, which is baby steps, I can order just a straight-up drug and alcohol
I think that makes sense,
assessment
Your Honor.
and give him the
the reality
credit
is-
for jail time?
Yes, sir, and Judge Marshall may put him in. We don't know yet.
Okay.
And in the event that happens, of course, we'll notify your probation department that he's...
Well, something tells me that if Judge Marcelane elects to impose a term of incarceration, that our probation department may just end up terminating supervision. It doesn't make much sense.
Understood, Your Honor.
Okay, all righty. So let's talk about your sentence at this point, at least in this court. On the speeding violation, it's a $79 fine. On the marked lanes violation, it is a $25 fine. On the reckless operation charge, it is a $100 fine. As far as the OVI is concerned, I'll impose a 180-day jail term. I'll suspend 177 of those days, give you credit for the 3 days that you were held in jail before I released you on your own recognizance, and I will place you under the court's supervision for a period of 1 year. You're obviously prohibited from consuming alcohol, using any illegal drugs, or abusing any prescription medication. You are to undergo, if you haven't already, a drug and alcohol assessment and follow up with any recommended counseling. You are required to submit to an alcohol or drug test if requested by any law enforcement or probation officer. Do you work?
Yes, sir.
What do you do?
Maintenance for Connect Housing.
Okay, so I'll go ahead and order that you maintain suitable employment, follow any other rules the probation department sets, and I'll impose the minimum fine of $565 as well as the court costs. Your license is going to be suspended for 1 year effective from the date of your citation on December the 12th. If I granted pretrial privileges, you'll have to submit a new application given the conviction. If you haven't up until now, you certainly have the right to apply, and my bailiff can assist you with that. There was no accident here, right?
No.
Okay. And you had insurance on your Chevy?
Yes, sir.
All righty. Okay, you'll be granted time to pay. They'll give you all the details down in the clerk's office. Do you have any other questions today, sir?
No, sir.
All right. Well, I was talking with somebody earlier today who did a change of plea on an OVI. It was the first ever offense that they had, and I was telling him that more often than not lately, what I've been saying to folks who are here on their second or their third is that I'd bet dollars to donuts when they were sitting here at their first offense getting sentenced for their first ever OVI, what was going through their head was, I'll never be here again. And yet those people were, and you find yourself here again. You can kind of put a divide between your previous life, and like I said, those priors were from the 80s, and this one. But this needs to be the last time you find yourself under these circumstances. Understand?
Yes, sir.
Do you have any questions?
No.
Anything further, Mr. Szymanski?
Not on this matter, Your Honor.
Anything, and I understand you need to
Yeah,
speak
yeah.
with me. I have one more hearing, and then we'll go ahead.
That's cool, thank you.
Ms. Yeager, anything else?
No, Your Honor.
All right, very well. You may go with the bailiff, Mr. Colson.
Thank you.
Thank you.
All right, and finally, we have Amanda McIntyre this morning. This is case number 26 TRC 03538. Are you Ms. McIntyre, ma'am?
Yes, Your Honor.
The record should reflect that the defendant is present in the courtroom today with her counsel, Mr. Bream. We have Ms. Yeager here on behalf of the state of Ohio, once again substituting for the derelict Mr. King, who's not doing his duty today. We're here for the purpose of a change of plea. The defendant is charged with a single complaint citation alleging the offense of operating a vehicle while impaired. My understanding, Mr. Bream, is your client's going to be changing her plea from not guilty to guilty.
That's correct, Your Honor.
Is that true, Ms. McIntyre?
That's correct, Your Honor.
Are you aware that you're not required to change your plea?
Yes, Your Honor.
Do you realize that you're presumed to be not guilty until and unless the state of Ohio could prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did you know that you have a right to have a trial with either a judge or a jury?
Yes, Your Honor.
And did you know that at that trial, you'd have the right to cross-examine your accusers and also to subpoena your own witnesses, which would compel their attendance?
Yes, Your Honor.
Are you aware that you would have had a right not to testify if you didn't want to, and the decision not to take the stand could not have been held against you in any way?
Yes, Your Honor.
By pleading guilty to this offense, Ms. McIntyre, you admit to committing the offense, which means you are surrendering your presumption of innocence. The state no longer has any burden to meet in order for me to find you guilty, and you're going to waive your right to have a trial and the other rights that we've discussed. You realize that?
Yes, Your Honor.
And if I accept your plea and enter conviction here today, I'm going to impose sentence upon you. Now, this is the first offense within a 10-year period. You are looking at up to 180 days in the county jail, up to a 3-year suspension of your driver's license, and a maximum fine of $1,075. You have any questions about that?
No, Your Honor.
At a minimum, the court has to fine you $565, suspend your license for at least 1 year, and send you to serve 3 days in jail. Although instead of the jail time, I can require that you successfully complete a 3-day driver intervention program. Any questions about that?
No, Your Honor.
All right. Now, Ms. McIntyre, have you been threatened in any way or promised anything to get you to do what you're doing here today?
No, Your Honor.
Are you under the influence of anything right now?
No, Your Honor.
Are you satisfied with Mr. Bream's advice and representation?
Yes, Your Honor.
And are you a citizen of the United States of America?
Yes, Your Honor.
The court finds that the plea and waivers have been knowingly, intelligently, and voluntarily made. The court's going to accept the same and enter a conviction on the record. Mr. Bream, would you care to make a statement of mitigation on behalf of your client?
Yes, Your Honor. Unfortunately, I have a lot to say about this. Amanda had a really bad night when this happened. She picked up a hit skip in Dublin, and I've worked that matter out, and we kind of just, so I know everything on the table. They're going to either dismiss the hit skip or reduce it to like a 2-point violation in exchange for a plea with the understanding sheet. You get 3-day program.
You might be able to even, well, no, I guess since it's probably a separate incident, they would still assess the points on both. So
Yeah.
anyway,
So
sorry to
she-
interrupt.
so
Go ahead.
She's in some hot water with points. So it's all kind of related material. She has, I think, 4 points on her license already, so she's going to have to do a point reduction course, a lot of work to do. The timing of this, very problematic in her life. She made an application to grad school in Chicago. That is still pending. One of the reasons why we were trying to get this thing done like really quickly is it might cause her problems in her enrollment there. So I mentioned that because she's going to have some driving privileges to go back and forth, and has some concerns here about like her reporting requirements on probation. She didn't have much of a record. It's a very bad night for her. She's cried, I think, pretty much every time I've talked to her. She's not crying today, but it's been very traumatic, and I can't guarantee it's never going to happen again, but I'd be quite surprised if it did. So she's remorseful, insured. Just a very, very bad night for her. So thank you.
All right, and I think the citation actually reflects the proof of insurance that's shown. It does. So, Ms. McIntyre, you have a right to address the court if you wish. Is there anything that you'd like to say about this?
No, Your Honor.
Okay, and Ms. Yeager, on behalf of the state of Ohio and for the benefit of Mr. King, is there anything the state would like to say before I make any decisions?
Your Honor, we would note that this is a true first offense for Ms. McIntyre, and unlike the last case, she did not get in a fight with two deputies. And she has a relatively recent driving history, so we don't see any need to treat this anything differently than a standard first-time penalties.
Fair enough. So, what will you be studying in grad school, Ms. McIntyre?
I did my. I apologize. I'm so sorry.
You're not the first person to cry sitting there.
I did my undergrad in cognitive and behavioral neuroscience. I got a 3.7 GPA, which I worked very hard for at OSU. And then on my weekends in undergrad, I worked in a group home with developmentally disabled kids. I did my volunteer hours at Nationwide Children's in the infectious diseases unit, and I ran a student organization in undergrad that helped get children under the poverty line access to literacy materials, and then I did my clinical hours in children's psychiatry at Nationwide Children's.
So, you want to be a psychologist?
So I applied to PA school, and I got 5 interviews the first round of applications and 2 wait lists. And then
So, you haven't been accepted yet?
I applied again,
Okay.
and I was finally accepted into Miami of Ohio and Chamberlain in Chicago. And I paid only one acceptance fee at Chamberlain in Chicago. And the requirements to be enrolled there are that you have to clear a background screening within 120 days of the start date of the semester, which is August 31st. And my advisor said, after countless emails and handwritten letters to the admissions committee, that he might be able to get a waiver for me. So, yeah, if not, there's other careers out there for me, but, yeah, I've always wanted to be a PA, so.
And by that, I'm assuming you mean physician's assistant?
Correct.
Where did you grow up? In Columbus?
Yes, Reynoldsburg.
Did you go to Reynoldsburg High School?
Yes, and then my senior year, I went to OSU full-time.
Main campus?
Yeah.
Okay. You got out in 4 years?
Yes.
Well, Ms. McIntyre, you can go ahead and dry your tears. You're not the first person who's found themselves in this circumstance, and with all the complications it's causing in your life. I always say that an OVI is not going to ruin your life. It's just going to make it very inconvenient for a while. And that's true here, but that inconvenience is going to be much more pronounced for you given your academic plans. You were here for the other 2 individuals that I imposed sentence upon. The first one was a young woman, no priors. Obviously, she wasn't as impaired as apparently you were on the night that you got cited. You know, we have the other individual who had 2 priors from 30-some years ago, probably 40-some years ago at this point. And, you know, as Yeager commented, not only was operating the vehicle while impaired, but because of his poor judgment and impaired judgment, elected to be combative with the police. It's easy for us as professionals to say, oh, this is just a routine first offense. I strive as a judge, and I strive as an attorney to always remember that no matter how routine it is for us, it's probably one of the most important things in the life of the person who comes before the court. So I treat every case, whether it's not using your turn signal or an OVI case or even a vehicular manslaughter case, as the most important thing in the world, because it is to that person. And you're no exception to that. So you have within your own power the ability to make sure you never find yourself in this circumstance again. Now, whether you elect to stop drinking, that's entirely up to you. It's not going to be a condition of your probation. It will be a condition not to consume alcohol to excess. But plenty of people who get their first OVI decide that they just aren't going to drink anymore. And if that's your decision, I will respect that. If it's your decision that you don't feel it's necessary to stop, I will respect that too. As our prosecutors and our defense bar tell every jury panel when we have a jury trial, driving after having a drink is not illegal. Driving while impaired is. Was anybody injured in the hit skip?
I think it's just my recollection.
So with
of
the
it,
parked
it's
car or
a
something?
Parked car. They get in an argument. She's like intimidated at the scene, or she shouldn't have left the scene. If she wouldn't have left the scene, none of this would have ever happened. And it's,
Well, thankfully nobody was injured.
and it also been way easier to work out the OVI if she would have stayed at the location in Dublin. So much better result if she'd done that. So
obviously nobody was actually injured, including yourself, which is good. But the potential for tragedy is always there with an OVI case. So, Ms. McIntyre, I will send you to what Ms. Yeager referred to as a routine first offender sentence, which is 30 days in the county jail, all but 3 days suspended. And when I say suspended, that means you don't have to serve the jail time as long as you follow the rules of probation. That'll last for 1 year, and that starts today. And the primary condition will be that you successfully complete a 3-day driver intervention program, if you haven't done so already. As long as you follow the rules that I'm about to lay down for you, you'll never serve any jail time as a consequence of this conviction. But part of the driver intervention program is a drug and alcohol screening. It's basically like a mini assessment. You'll be required to participate in that. If they make recommendations for follow-up counseling, you'll be required to continue until released in writing. If they don't make any recommendations, you'll have no obligations in that regard. As I mentioned, you're not to consume alcohol to excess. I will put a complete prohibition on the use of any illegal drugs or the abuse of any prescription medications. So have you already graduated from Ohio State?
2023.
Okay, so do you work now?
Yes.
Where do you work?
I work at Moorfield Country Club.
And what do you do there?
I'm a server.
And what's it called again?
Moorfield Country
Oh,
Club.
you work at Muirfield. Okay, all right.
Do you work for Mr. Stout?
No.
You don't have any interaction with him?
I'm at the country club, not the village.
Okay.
All right. You'll be required to either be working or going to school or a combination of the two. We want you either earning, learning, but definitely being productive. Other than that, you got to follow any of the rules the probation department sets for you. First-time OVI offenders are not closely supervised unless they give the department a reason to closely supervise them. So you do what you're supposed to do, you'll probably meet your probation officer once. All right? I'll impose the minimum fine. That's $565. You're going to be ordered to pay the court costs as well, and we'll give you time to pay. You'll get the details when you get down to the clerk's office. It'll be a 1-year license suspension effective from the date of your citation back on May the 11th. If you already enjoy driving privileges, you'll have to submit a new application in order to continue to enjoy those. I would caution you that if you're going to ask for privileges, which are typically granted after on a
What happens when a defendant begs for one last chance, but the judge refuses to accept excuses? This courtroom hearing delivered exactly that. One of the most emotional moments came when Matthew Castro stood before the judge asking for probation instead of prison. His attorney presented witnesses who described him as a hard-working employee, a loving son, and someone with a job waiting for him if he were given another opportunity. His employer even testified that Castro had been one of his best workers and wanted him back on the job. His mother spoke through tears about the difficult events their family had endured, including the devastating shooting of Castro's brother, and how she believed her son had finally matured and was ready to rebuild his life. Then